Good evening, viewers, and if you're watching this program with us, this is week 9 of our Can You Fix the Nigeria Challenge. I have with me tonight a legal practitioner, Mrs. Adeola Sunmola. She's a partner at Udoma and Bello Osagie Partnership, law firm in Nigeria, based in Lagos, Nigeria. She works in their banking and finance, power, and infrastructure department. Ms. Adeola, you're welcome to the discussions tonight.
Thank you, Kunle. It's good to be here.
It's good to see you, looking bright and everything. Thank you for joining us. We know you people like you are very busy, but
my pleasure.
I appreciate that time. So tonight we're discussing about the judiciary system in Nigeria. And we're looking to you to give us a bit of a background, to give us some education, to look at some of the challenges in our judiciary system and how how we can develop that sector better to serve the people of Nigeria better. I would like to start tonight by asking you if you could give us a brief background on what the appellant system in Nigeria is. What kind of judiciary system do we have in Nigeria?
Okay. The Nigerian court system is hierarchical in structure, with the Supreme Court as the apex court, followed by the Court of Appeal, the National Industrial Court, and the high courts of the states, both the federal and the state high courts. And that's closely followed by the magistrate courts and the customary courts. The Nigerian court system can be classified into superior courts, which are essentially courts that are created by our constitution. And these courts of records are the courts from the high court up. So the High Court, the National Industrial Court, the Court of Appeal, and the Supreme Court. All of these courts are created by the Constitution. And there are other courts that are classified into inferior courts. So these are courts that are not created by the Constitution, but are created by laws of various states where these courts are located. And these are essentially the magistrate courts, and the customary courts and other courts within or across several states.
Across several states. So thank you very much.
The country. Yes. Do you want me to talk about each court briefly?
Yes, please go ahead. We'll appreciate that, at least to shed more light on what we have. Yes.
Absolutely. The Supreme Court is the highest court in Nigeria. I'm sure many are aware of that. It's an apex court that determines appeal matters, and it hears appeals only from the Court of Appeal. The decisions of the Supreme Court are final, and they can only be overturned by a subsequent decision of the Supreme Court. So by way of example, the Court of Appeal cannot overturn a decision of the Supreme Court. Yes. So lower in the hierarchy is the Court of Appeal. And the Court of Appeal is essentially next in line to the Supreme Court in the hierarchy of courts in Nigeria. The Court of Appeal is bound by the Supreme Court and its decisions, and it hears appeals to the exclusion of any other courts from the Federal High Court, the high courts of various states across the country, the Sharia Court of Appeal of the state, the Customary Court of Appeal of the state, and in some cases, it also hears appeals from the National Industrial Court. So after the Court of Appeal, we also have Federal High Courts and State High Courts, right? The Federal High Courts have, so it's one Federal High Court, but it has various divisions, what we call various divisions across the country. I think there are about 30 divisions of the Federal High Court now. So the Federal High Court is the Federal High Court, but it has various divisions in different states across the country. And the Federal High Court has exclusive or regional jurisdiction in respect of certain matters that are specified in our Constitution. So these matters range from matters dealing with banking, with telecommunications, with intellectual property, with taxation, securities law, and similar matters.
So Adeola, let me ask you a simple question there. Does
Sure.
that mean that if we are taking because you mentioned the question of jurisdiction now, yes. What I'm taking from that is that it means that the first point of call for any case should be those kind of high court. We cannot go straight to the Supreme Court or to the appeals court for a first hearing of a case.
That's correct. That's correct. Because the way appellate courts work is that appellate courts only hear appeals.
Okay.
And they hear appeals in relation to matters that have already been tried.
Okay.
In other lower courts.
Lower court.
There are a few exceptions, but that's the basic principle.
That's the basic principle. All right.
Yes.
There's a second question I wanted because now you mentioned the issue of the appellate court, and obviously we're asking these questions so that we will build into something. Sure. I understand that typically, in terms of international law, there are two schools of thought. There are courts which are based on, or legal systems which are based on precedents, and then there are some which are based on direct interpretation. What do we use? I understand we follow the British system. Is that correct? Okay. Yes. So can you shed a little more light on that for us, please, and why this is important?
We do both. So Nigeria, yes, we do both essentially. Nigeria has a process of, it has a process where precedents of former courts of superior record are binding on lower courts. So when I was talking about the Supreme Court, I did say that, the Supreme Court being the apex court, I gave an example that a decision of the Supreme Court can't be overturned by the Court of Appeal. It can only be overturned by the Supreme Court itself. So what a decision of the Supreme Court would be for other lower courts, such as the Court of Appeal and the federal and state high courts, is what we refer to as judicial precedent.
Okay.
Which those lower courts will then follow.
All right.
Right. Okay. But judicial precedent isn't restrictive. It isn't limited to, a court following the decisions of other superior courts in the hierarchy. The concept of judicial precedent simply means that a court would follow the decisions of either that court itself or the decision of a higher court of record.
Yeah, a superior court. Okay.
Yes.
Clear.
Yeah. So still speaking about the court hierarchy, let me just briefly talk about I've spoken about the Supreme Court, the Court of Appeal, and the Federal High Court. So there are also high courts of states.
Okay.
Each state across the federation has a high court within its states, even though each state may have several divisions of that high court. So I'll give an example. In Lagos State, we have several divisions of the High Court of Lagos State. We have the divisions in Lagos Island, in Ikeja, in Ekpe, and in Ikorodu. Those are examples of the divisions of the Lagos State High Court that exist within Lagos State. And all of these courts, all of these divisions have offices where the judges sit, and they have courtrooms for the dispensation of justice.
Please let me ask you a question then. If there's a state high court and there's a federal high court, is the federal high court higher than the state high court? Are they at the same level? Can you clarify that for us, please?
Sure. The federal high court and the state high court are par.
Okay.
One isn't higher than the other. The main distinction between a federal high court and a state high court is that the federal high court has exclusive jurisdiction over certain matters.
Federal matters.
Yes, over certain matters. And the nature of those matters are specified in our Constitution. So that's where you see where, for example, a matter in respect of which a federal high court has exclusive jurisdiction has been taken to a state high court. council can raise a preliminary objection that the state high court lacks
has no jurisdiction. I see.
To hear that matter.
I see.
And that instead the matter should be instituted
to the
federal high court. Yes.
Very clear. Very clear. Thank you very much. You see, you learn one of these things every day. Listening to you, subject matter experts on these things. All right. Now, I will say as a layman, let me tell you our own impression of the court system, and you correct me whether I'm wrong or not. I suspect that the feeling of majority of Nigerians, right, is that our court systems are not working. And we could be wrong because some of us are looking from outside in. Do you understand? Now, and we will say this for a number of reasons, yeah? One, it seems that cases take forever to be resolved. This is one thing. Then I'll give you a very quick example, and then I'll give you 2 or 3 minutes to answer all of these questions. I remember many years ago, there was a very popular case of Mr. Bernard Lunge, who was MD of First Bank. And he was removed from court. I mean, he took his case to court, and that case, I remember, went on for about 8 years. By the time they finished that case, First Bank had 2 subsequent MDs. Yeah? And for me, that just shows you. Now, he won that case when he eventually got to the Supreme Court, but there was no point of him winning the case because time has just simply bypassed the relevance of that case. Yeah. So this was this is one problem that those of us looking from outside in see. The second problem is that there also seems to be a question as to the integrity of the court sometimes. About 2-3 years ago, there was this big case where this present government was making warrants to arrest people, including judges in the Supreme Court. Now, but we don't know how things have been resolved. So this is the perception of those of us who are looking from outside in. What do you have to, what can you say about this? Why does it seem that the cases are taking so long to be resolved, for example?
Okay, so Quille, I have a question for you. Do you want me to discuss the problems or the solution or both?
Both. I want to discuss both because I think we will be better off if we understand. Because see, you know why I said that, Adeola? Because part of the problem is that I could be saying these things and I could be wrong because I'm looking from outside in. But for people who are in the system, you understand the challenges that system has. So it will be better for us to understand what the problems are from you and what you think we can do to make it better. Please go ahead.
Sure, okay. Right. Yes, I would be lying if I said there were no problems. There are problems. Okay. And there are a couple of them, right? But there are also solutions. And I think that with time, we will get there. Okay. We've come a long way, and Nigeria is so fundamental. Its economy alone is so fundamental. The country holds a vital position, not just in West Africa, but in Africa as a whole. So, okay. So we have to, as a nation, continue to work on ensuring that our systems are more efficient and that they do live up to their through standards of potential. So let me start by discussing the problems. Okay. Many of the courts in Nigeria are overwhelmed. Okay. And when I say that they are overwhelmed, I mean that there are several facets to this. There are a backlog of cases. Right. So let's start with that. Why are there a backlog of cases? This isn't just because the system is inefficient. Okay. Right? Okay. It's also because Nigeria as a country operates in a manner that sort of, facilitates the filing of what I call frivolous cases by litigants. I see. Yes. I see. Okay. And so whilst on the one hand, people may be alleging that, the court system is slow, but then on the part of litigants, are we stepping back to actually see why whether some cases should actually make it to court? To court or not, okay. So I am a banking and finance lawyer, and let me start by sharing some of my experience with you.
Okay.
As a lawyer that advises a lot of lenders in Nigeria and elsewhere. So on many occasions where lenders advance a loan to a borrower, and the borrower is either is on the brink of default, and he foresees an imminent enforcement of security and an imminent enforcement of collateral.
Yes.
By the bank.
Yeah.
He rushes to court and sues his lender.
Okay.
Okay, and sues his lender, challenging various things, but they usually start with the interest rate that has been applied on the loan.
I see.
Right? It challenges interest rates, it challenges the nature of security in some cases, and various other things. That's just an example. Okay?
Okay.
But quite apart from that, on the banking side of things, in many cases, a lot of matters go to court and they shouldn't be in court in the first place. Many matters can be resolved by arbitration or mediation or conciliation.
Okay.
You see what I mean?
Yes.
But because of the way our court system works, there isn't really a filter. You understand? In some jurisdictions, you can't file certain actions in court. You would have been required to explore other means.
You know, Adeola, that was exactly the question I was going to ask you, is that don't we have a filter system that says maybe you have a registrar of courts that looks at these cases first and then filters the ones that we think are frivolous before it goes to a judge? I see that as a layman, but then somebody else could also argue that if the guy registrar has filtered my case, then what recourse to justice do I have? You see what I mean? So it's a catch-22, isn't it?
We don't have that kind of sophisticated system, unfortunately. Okay. Yes, we do have a system for arbitration, mediation, and reconciliation, but that system is often ignored, actually, by some litigants.
Are the rules of that system binding? For example, if you go to arbitration, is that rule binding? Is it binding officially? It is. Okay.
Yes, the arbitral award will be binding on the parties. Okay. So that's the first challenge. Okay. And because of the way our court system works, it means that there is a backlog of cases because the courts are overwhelmed. There are hundreds, if not thousands of cases in the dockets for that span several years. Okay. So, and for this reason, there's been a congestion in our courts, and ultimately this has led to delay in determination of cases and in dispensation of justice. Right. So the second problem would be inadequate court infrastructure. Right.
Okay.
And I don't think, yes, there's been some improvement in some states such as Lagos in the past, few years since we came back to democratic rule. But we still have a long way.
A long way to go.
We still have a long way to go. The court system the infrastructure isn't sufficient. We don't have in many courts the judges still writing longhand.
Yeah.
Okay. The judges still, and that slows things down, because if you're taking down what every counsel, at least a minimum of 2 counsel on each case, if you're taking down notes from them, and you have several cases in your registry in a day, I mean, how much can you do? You understand? How much can you as a judge do? So that's one of the challenges. There's also insufficient judicial and non-judicial personnel across our courts. It is what it is. What it is. Across the various courts, there's just
so court recorders. You're talking about court recorders, assistant to these judges, people who should help them take notes,
registrars. Yes,
I see. Yes. But Adeola, in the US, for example, I mean, I know that judges in the US have clerks who are essentially students who can carry a bit of this burden. You know, they do analysis for them, they help them to summarize their account notes and all of that. Can't we have a system like that in Nigeria to help alleviate some of these problems?
We do have some judicial assistants and clerks in some of our courts as well. Okay. But it's just not enough when you take into all the other factors into consideration.
Okay, I see.
Factors such as filing of frivolous cases, the backlog of cases. The backlog
which already exists.
Yes,
I see.
Yes.
I see.
And then another problem I'd like to mention also is that even litigants on their part, sometimes they raise unnecessary objections in the course of a case in order to delay that case. So let me give you an example. If a matter has been filed in a state high court, and then an objection is raised, okay, on that matter, and then the court gives a judgment on that objection that is in favor of one party and not in favor of the other party. The other party has a right to appeal.
Yeah.
Right? Sure. And so in many cases, you know, they enforce that right of appeal in relation to a preliminary objection up to the Supreme Court.
Oh my God. So basically,
in the course,
way all to the Supreme Court.
Yes, on a preliminary objection.
Oh my word,
yes.
I see. Not on the substantive case itself.
Not on the substantive suit.
Okay, I see.
And what this then means is that an objection, whether frivolous or not, could take 10 years.
Oh my
It could
word.
take 10 years in court to resolve an objection before you then go to deal with the substantive
with the case itself.
Now let's talk about problems with the substantive case itself. There are many days when you go to court and you see that, you know, you as a lawyer know that you should be ready for trial, your witnesses should be ready, and you hear people saying things like, my witness is not ready, he called me this morning to say he's traveling from somewhere, to things like that.
But can the judge rule against you for that? I mean, I'm a judge. Somebody comes and tells me you've been notified that you have a case. Your witness, you should get your witness ready. And you come and tell me your witness is not ready. I will proceed with the case. Can't the judge do that?
You know, these are the problems. A judge would want to give everyone the right to be heard.
Wow.
Okay. Wow. So it makes it more challenging.
Okay.
And so when people say things like, you know, cases are being adjourned for long, these are the reasons why.
Why? Okay.
Because the courts have failed.
Failed.
I've talked about the problems. Let me talk about, do you want me to talk about the solutions?
Please talk about the solutions. Yes. Talk about the solutions.
Yes.
Okay.
Yes. So I think in the 21st century that we are in now, the first solution would be technology.
I agree.
I think that our courts would need to leverage on technology for a speedy dispensation of justice. So first example, where some cases can be heard virtually.
Okay.
We've seen it done during the pandemic. There were challenges.
Correct.
There were challenges, but we've seen it done during the pandemic. So I think that we would need to establish a system that permits this to be done on a long-term basis. Not for all cases, though, but certain cases, it needs to be encouraged.
In particular, yeah.
It needs to be encouraged.
Okay.
Digital databases, you know, to be able to access records of courts, the use of technology to record court proceedings, to record the proceedings so that judges are not as stressed as they often are. You see what I mean?
I do.
And then the e-filing of certain cases. You understand?
Yeah.
I don't think that in this century you have to walk into a courtroom all the time to file a case.
A case.
Yes.
Wow. Okay.
I think some of it can be done digitally.
Those are very, very good ideas. And you know what's surprising? I mean, you mentioned about 4 things there already, you know. And what surprises me is that those are simple things to do, actually. You know, to be able to have a database to allow people have a portal that allows people to file cases electronically, to have electronic recording systems in the courts, which we can then transcribe and things like that and take pressure off. So those things are possible, and those are very good solutions. Thank you very much for that. Let me switch the discussion a bit. There are 2 other areas that I wanted to talk about with you tonight. One is the issue of prison reform. Do you understand? I mean, anywhere you go in Nigeria, you hear about how much people are in prison, are waiting trials and things like that. It's a major, major, major problem, you know. I wanted you to please shed some light on that. What can we do again? Talking about solutions to resolve that. I mean, there are cases of people who are waiting for bail of 5,000. They've been lost in prison for 3, 4, 5 years because nobody can pay that for them, you know. How can we address those kind of issues? So this is one question. And then when we finish that, I would like to narrow in on the Supreme Court. But let me allow you to respond to this first. Prison reforms, what can we do?
Yes, I think that there needs to be a mechanism in place to ensure that even the prisons do not take on detainees that are, for example, entitled to bail.
I see.
Okay, I think that so that's number one, and also I think that it would be helpful if some courts do not, for certain offenses, do not impose bail conditions that are difficult to meet. Because I think personally, I think this is one of the reasons why our courts are congested, why our prisons are congested.
Okay.
Yes, because if there is a criminal action against a person and the criminal action goes to court and an application has been made for bail and is unable to meet his bail conditions, what happens is that he's then detained in the prison. And sometimes these offenses are even offenses that have a very short term.
Correct.
Short term in terms of if the person is actually convicted. I have heard of a case where the accused person was in the prison for longer than the term that could have been granted by the court if he had been convicted of the crime.
Yes.
So I think that would be one way to look at it. Then I think probably we need to improve on any frameworks that we currently have in place for assisting the less privileged.
Less privileged, I see.
The less privileged in terms of having access to justice. Not everyone can afford the services of a lawyer. And even though the legal framework, there's some offices for supporting these kinds of people within our current legal framework. But I think that they may have their own challenges, which
but we need to expand it effectively.
But we need to expand it so that so that it ultimately leads to improvement in the dispensation of justice.
Please let me ask you another question there. You mentioned the fact that there are some things which are small, and we don't need to. Okay, so let me give you an example now. I know that maybe in the US and the UK and all those other places, for small things, traffic offense, this, that, people can do things like community service. Do we have that kind of system in Nigeria as well? I.e., instead of sending somebody to prison for 3 months, or he has a fine of 30,000, 40,000, do you understand? Do we have a system that says that guy can go and do community service? Do we have
Yes, we do.
We do.
Yes, we do. So we do have a system.
Okay, so that's very good. Okay, so that answers another question. So let me switch it now to the Supreme Court. You see, when you explained to us at the beginning of the discussion and you were telling us about the appellate court system, I see that our system mirrors to a large extent the US system. to some extent, you know, appeal courts, federal appeal courts, Supreme Courts, that kind of thing. The UK, for example, didn't have a Supreme Court, as far as I know, until about 5 years ago. They didn't have a Supreme Court. They used to have the House of Lords. Now, my worry, though, is that when you look at the US Supreme Court, they've always had about 9 people for the last 100 years or 150 years. In the Supreme Court of Nigeria, my understanding is that we have about 32 judges at the moment. Is that correct?
No, not entirely correct. Not entirely correct. So the Constitution. Go ahead, finish your question.
Supreme Court then? How big is that Supreme Court?
So the Constitution says that the Supreme Court can have up to 21 justices.
Up to 21. Okay.
Yes, including the Chief Justice.
The Chief Justice himself.
Yes.
Okay. So, but does that not make it expensive to run? I mean, as per Nigeria's Constitution, the Chief Justice of Nigeria is at the Vice President status, right?
I actually don't think so. I actually don't think it makes it expensive to run.
Okay.
And this will take me to one of the debates that has been ongoing as to how, you know, how to make the judiciary more efficient. There is a debate about whether we should have regional Supreme Courts.
Okay.
Because we have just one Supreme Court.
Okay.
You know, where all appeals go to.
Yeah.
Yes, where all appeals go to. And, you know, this Supreme Court, yes, it should have X number of justices. And they are required to sit in panels of either 5 or 7, depending on the nature of matter.
I see.
Depending on the nature of matter that's been adjudicated.
So not all the 21 seats, they split them into panels. I see.
No, Kule. So that's the maximum number that can sit on a case, either 5 or 7. However, they can have up to 21. What's happening in practice is that not many panels sit on a day.
Okay.
Right? So on a typical day at the Supreme Court, you have only one panel sitting. And that panel can have either 5 justices or 7 justices. Depending on what matter is being adjudicated.
Okay.
So one of the ongoing debates is whether it is possible to have at least 2 panels sitting at the same time on different matters.
Okay.
Right?
Okay.
And secondly, whether it is possible for the Supreme Court to have regional offices.
Okay.
Across the country.
Okay.
So that, you know, these regions or these, you know, panels can then hear more cases than
in those regions. But
yes.
but let me ask a layman's question then there. So let's assume that you have a Supreme Court region, one in the north, in the south, in the east, and in the west. Assuming, let's take the example that somebody's sitting in the east and is in Enugu, for example, and you've put 7 judges there, but the Chief Justice of Nigeria is not in that panel. Yeah? If those people make a final call, can somebody then appeal to another panel that the Chief Justice himself sits on? Or
no, there's nowhere to appeal to.
Exactly. So
you can't appeal a decision of the Supreme Court. When we were in law school, there was a joke that you can only appeal a decision of the Supreme Court to God.
To God, I see.
You can't appeal
we used to be able to appeal it to the Privy Council. Okay, but then, okay, yeah, all right. So I see what you mean. Okay, well, okay. So bottom line, what you're saying to me though is that the size of the court can go up to 21. And that doesn't necessarily make it more expensive to run, yeah?
No, it doesn't. Okay. It doesn't, because the Constitution already provides that the Supreme Court can have that number.
Okay, so let's go to the next one then. The next one, you know, I asked the question and you've not addressed that yet. It was this issue about corruption at some point, and I know it's a touchy subject, but please just handle it the best you can. I know that a few years ago, there were some judges, including a judge in the Supreme Court who was accused of corruption. And and then it became a bit messy, you know. There was a judge from the Federal High Court in Lagos. Now, what is the Nigeria Judicial Council doing to root out this problem? And what improvements can we make in that process?
Yeah.
By the way, I don't even know how that case was resolved. I don't know how that case was resolved. Was it ever resolved? And how was it resolved? What improvements can we make?
Okay. The NJC is doing what it should do. First, it's supposed to be independent.
Correct. Okay? Correct.
It's supposed to be independent. So it would be good to see that independence coming through. Even though it is encouraged, in practice, the implementation of the rule of law in Nigeria is largely aspirational. It is what it is. It is what it is. It is what it is. And unfortunately, there is allegedly influence from other arms of government. And I say allegedly because, yes, and I say allegedly because I'm personally not aware of many cases where this is so. But one thing I would say is that the way our systems have been set up, both the executive, legislative, and judicial systems, it's been set up in a way where the rule of law is encouraged, and that each arm of government should be independent of each other.
Correct.
Now it is left to us, so that's in the law. It's left to us as a nation, as citizens, as individuals, to do what we are supposed to do.
To uphold that independence.
To uphold that independence.
I see what you mean. Yeah.
To uphold that independence. That's what I will say. Yes, there have been allegations of impropriety, but we do have a legal framework that ensures that independence can be achieved. So it's left to us to make the best of that framework.
Of that. But in terms of remuneration, how are judges doing? Are they adequately compensated?
I haven't heard complaints.
Okay. No, because
I don't think I've heard complaints.
Those are the areas where, you know, where these problems start, you see. So
I mean, I know a few judges at the state level, and quite frankly, I haven't heard complaints.
Okay, that's good.
I think that, I haven't heard complaints. I mean, I think, so apart from the judiciary, I think that, you know, there are also cases of corruption elsewhere.
Oh,
you
no,
know.
for sure.
So the question is, why is there corruption? Is it that we have, why is corruption rife in Nigeria? Is it that we have a system that enables it? Is it that there isn't sufficient
punishment for it, repercussions?
Yes. Is that the case? And I don't think so. No, I don't think so. I don't think that. I mean, we have many cases of political office holders, of chief executive officers, having faced the wrath of the law on account of allegations of corruption.
Particularly recently, yes. No, I see where you're coming from. I think where the issues are is that, at least for those of us who are members of the general public looking from outside, we think that it takes a long time, so people just continue with impunity. But I think you've covered.
It takes a long time to do what, Kunle?
No, for them to arrive at that. Okay, so for example, you mentioned some chief executives now, right? Recently, I believe it was earlier this year or late last year, Mr. Kalu, who was former governor of Akwa Ibom, was sentenced to prison. But remember, this guy was governor in 1999. So it's taking about 20 years. Do you see my point? And so sometimes that's why people think that there's something wrong with the system, because it takes a long time for it to actually deliver that justice. But you explained the reason why earlier. So I can see where you're coming from. being conscious of the time, I'm going to start rounding up now. Yeah. The only thing I was going to say though is that we talked very briefly about the Nigeria Judicial Council, the NGC. How is that council itself constituted? Just for the education of our listeners at home, and which level of judges do they appoint? Do they appoint all judges, or is only judges at a particular level? I think I lost Adeola for a second there.
Judges. Would you like to repeat the last question?
Adeola, can you hear me? All right, viewers, in this particular case, I think I've lost Mr. Adeola. Mr. Adeola, are you back with me?
Apologies.
All right, no problem. I lost you there for a minute. So my last question actually is, the NGC, we spoke about the NGC, all right? And my question was that NGC, who constitutes the membership of the NGC? This is one. And two, do they pick all judges, or they only pick judges of a certain category? Do you understand? A certain level. I think, yeah, this is really my last question for the evening. If you could help us shed some light on that.
Okay, can you hear me?
I can hear you, yes.
Okay, the membership of the National Judicial Council is varying. So you have the Justice of the Supreme Court as the chairman of the council. There is a deputy chairman of the council as well. And then other members of the council would be picked from the Court of Appeal. Some retired justices also comprise part of the body, as well as certain judges from the Federal High Court and the State High Court. So essentially, I think your question is more along the lines of whether the NJC is only comprised of justices of the Supreme Court. No, that's not the case.
That's not the case. Okay.
That's not the case. So the Chief Justice of Nigeria is the chairman, yes. But then he also has other members that are
from
picked
other places.
Yeah, from others, including retired justices, the chief judge of the Federal High Court, Chief Justice,
President of the Federal Appeal. Okay, I see.
Chief judges of various states in the country. Yes, I think justices from some Sharia courts, and actually also members of the bar.
Oh, members of the bar as
bar.
well. Oh, yes. Okay. Oh, so maybe senior
members of the bar.
Okay.
Yes, I think the qualification is that one of them should be at least a senior advocate. So, yeah.
Okay. So do they pick only senior judges, for example, only judges in the appeal court and the Supreme Court, or all judges must be ratified by the NGC?
How do you mean? All judges?
So say, for example, a governor in a state appoints a judge. Who appoints the judge in a state high court? Is that the governor of that state?
Is the governor, yes.
Oh, it's the governor of the state. He's not
the governor of the state.
I see. I see. Okay.
No. The NGC is an independent body.
Body on its own.
But at the state level, the state governor appoints judges.
Judges at their own level.
Yes.
Wow. Ms. Adeola, thank you so much. It's been a great pleasure having you. I would have wanted to keep you on, but certainly I need to be conscious of the time. Thank you for shedding so much light on some of these things for us. And we will hope to come back and speak with you in the future if we need to pick up on some of these topics again. Thank you so much for being with us tonight.
It's been a pleasure, and apologies for the slight itch.
Well,
it's been a pleasure.
Not a problem at all. Thank you very much, and enjoy the rest of your evening.
You too.